Hello everyone and welcome to Robots Reading Reddit. If you've ever watched this channel before, you will for sure know about my passion for law and the insane things people do in courtrooms. So I just noticed another thread called Lawyers of Reddit. What's your best most badass I rest my case moment? Which we obviously have to read, and we might even learn something. But I wouldn't bet on it honestly. Also, the thread is currently 7 hours old, but making one of these videos takes like 2 days. So I'm guessing this will go up on Friday. I'll stop the rambling now, for a short while at least. Here's the first post by me, Auschwitz in there. Not a case winning moment, but a motion winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried multiple times to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. So, what is a motion? After doing the literal minimum of research, using Bing to Google the word, I found out that a motion is when one of the parties asks the judge to rule on something, like a motion to dismiss, which I think is the one we all hear about most. Usually it's all just paperwork, but sometimes the judge calls for a motion hearing. Let's see if corporate lawyers Ev's comment can teach us anything. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, "Well, of course it's fine when we ask for it." I think what we learned is that Zev doesn't know what exciting means. Not a lawyer, but defending my case in a small claims court when something similar happened. Landlord had not paid back deposit and then said that they would, and that they generously add 5%. So it's like no big deal that we are 4 months late with it. When it was my turn, I point out that their fee for late payment was a generous 20%. I could see the judge smile at that. I won, but I probably would have anyway, as it was an open and shut case. As in Ohio, if they don't return it in time, that's the end of it. Got sent to a negotiation without someone senior to me when I was a youngster. I had one kid junior to me there as well. These people on the other side tried to tell me that the indemnity I was asking for was off market and kept refusing to give it, which was total BS. I said, "I'm having my colleague look at your publicly filed deals, and we'll see if it is off market." Kid goes on Edgar, finds 3 deals in the prior 24 months, where the provision I was asking for was in their docs. It was one of those let's lock everyone in the room until it is done type of things, and my client was so pissed off by their lie that we took a break and I told them to pack their stuff and pretend they were going to the airport. The moment 2 guys closed their laptops and said they were leaving, the other side turned on a dime and caved on something like 11 of the 13 items on our open issues list. It was beautiful. God bless the Great Recession and cash-rich clients. And now, in classic Reddit spirit, we will continue on with a thread that begins with, "I'm not a lawyer. That's how you know it's real front page stuff." I'm not a lawyer, but I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and wind so strong that the defendant could only open his window 3 inches, and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car through a 3-inch crack in the window on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. I'm guessing it wasn't for a nice spot of tea and some scones. And that's why we need good public defense attorneys. A cop testifies about something he does not remember properly and just fills in the blanks. Good thing the defendant's lawyer caught it instantly. Let's move on to IP law with user an Aussie bum. What's up with the names in this thread? They're better than the comments. IP lawyer, deep in a set of terms and conditions on a website. Our client's details, name, and contact details were listed. So it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Ctrl+F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Alright, so before the next story I need to tell you guys a bit about a thing lawyers do and why. It's called pro bono work, meaning that the firm and the lawyer does the work for free. I wondered about why anyone would do that for a really long time, so I decided to find out why. So the reason firms and lawyers do pro bono work is because of something called the American Bar Association Model Rule 6.1. I think. I'm not a lawyer, I'm just a robot that can read. Kind of. Anyway, the 6.1 rule is basically an agreement that a lawyer should aspire to do at least 50 hours of pro bono work per year. I'm guessing this is because it's a good experience and also to alleviate some of the stress on the public defenders. If you're interested in learning more, I will put a link to the 6.1 rule, and you should also watch Last Week Tonight on public defenders. Now let's get into the story that created this tangent. I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "F you, judge lady. You a stupid C word. F you all for taking my effing kids, you effing C word." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. I'm not a lawyer, but the most memorable court scene I witnessed was 1968, Sacramento, California. I was waiting to be tried in traffic court, my usual speeding, before Earl Warren Jr., the son of the great Earl Warren of Supreme Court fame. The guy before me was being tried for reckless driving. When it got down to sentencing, Earl Warren Jr. ordered some nominal fine and that the defendant attend traffic school. The defendant got all upset and began ranting how he didn't need to go to traffic school. As the defendant slowed down, Earl Warren Jr. calmly stated, "Well sir, I cannot make you attend traffic school. I can only issue the order for you to attend. If I find after 2 weeks you have not attended, I will issue an warrant for your arrest and place you in county jail for 30 days. At the end of which I will renew the order for you to attend traffic school. So we can keep you going in and out of jail until you decide to attend traffic school." The guy just grumbled and walked out of court. Don't know if he did go. I certainly did when I got a similar sentence. The next defendant is playing some 4D chess for sure. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. He doubled down. Either he gets clocked for going 17 miles per hour over the limit, which is probably not great overall, maybe losing his license, and some serious fines. 5 miles per hour over the limit is probably nothing more than a small fine, and he can move on with his life. If the court didn't buy that he went as fast as he could, he got stuck with both charges. One for 5 miles per hour over the limit, and one for going 17 miles per hour over the limit. Really brave dude, honestly. Let's hope it paid off for him. I have two that I like to share. I'll apologize upfront for the length of my response. The first involved a lawsuit against the owner of a Mexican restaurant for not paying his employees and keeping the waiters' tips. He was just a terrible all-around guy. He created these fake handwritten schedules and payroll records going back years to try and prove that his employees didn't work but a few hours each week and were paid for what they did work. It was difficult to prove they were fakes, but we managed to trap him during his deposition. I made the guy go through random bits of his work schedule and asked him to confirm they were correct. We did a random week in February, March, April. Then we got to May. So here in early May, you had 2 servers working every night, 1 hostess, 1 bartender, and 2 cooks. Yes. And that didn't fluctuate. You didn't have a need for extra staff on, say, weekend nights. No. It was very steady, no matter the day. What about on this Wednesday? How much staff did you need? Just the 2 servers, my hostess, the bartender and 2 cooks. The same as every other night. And if you would indulge me, what date are we looking at? May 5th. Okay. So it's your testimony under oath that you had the same staffing needs on May the 5th as you did on May 4th and May 6th. Yeah. Opposing counsel's head begins to hang while shaking. So you are comfortable telling the judge you didn't do extra business on May 5th? Yeah. Or June 17th, or whatever date you pick. It was always steady. You have no problem walking into court and telling the judge and the jury, under oath, that your Mexican restaurant didn't need any extra help on May 5th. That these schedules and payroll records you've produced are 100% accurate. For Cinco de Mayo, you are totally comfortable with doing that? Yeah. The case settled within a week. That dude played himself. A deposition is done before the trial and the person being questioned is under oath. So like most cases it didn't go to trial. Honestly kinda lucky for him, because he saved himself the costs of going to trial. Story 2. State law enforcement was trying to prosecute a local cop for accessing name and address information for an individual in the state's criminal justice computer system to help a friend who was a process server. The state was prosecuting the cop for violating the Computer Crimes Act, which, in part, makes it illegal to share any information which the state has an intellectual property interest in. We show up for trial, having waived our right to a jury, and allow the head of the Attorney General's litigation department to make this wonderfully colorful speech about a police officer breaking the public trust and this other nonsense. For our opening statement we moved to dismiss the indictment on the grounds that the state's theory of the case is a legal impossibility. The state cannot have an ownership interest in someone's name or address. The judge was annoyed with our tactic and put the screws to us by asking dozens of questions, but we kept repeating our theory: the state cannot own a name or address as intellectual property. Finally the judge gets it and turns to question the Attorney General. He tries to dance his way out of answering the big question all sorts of ways. Eventually the judge flat out asked him if he contends the state can own someone's name or address. The Attorney General responded by saying, "Judge, I came here to try a case, not to argue the law." The judge was not impressed and dismissed the case immediately and wrote a letter to the Attorney General asking him to be more selective in his prosecutions. That was a fun day in court. I guess maybe you shouldn't become an attorney if you don't want to argue semantics. Even though semantics sure seems important. The next top post is from Tinaya Jama. Complaining witness accused my client of harassment/stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes. In this photo, he's on a bed? Yes. The bed is yours? Yes. The bed is in your bedroom? Yes. You took this photo of him? Yes. He's smiling in the photo? Yes. And in this photo, he's wearing your brassiere? Yes. No further questions, Your Honor. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion before my matter began. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the element of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called, and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. So really quick, before I go, I want to explain what makes an expert so important for a trial. All other witnesses can only talk about what they experienced and what they know. They are not allowed to talk about their opinion, which is what experts do. They are allowed to present their opinion about the facts laid out during the legal proceedings. If you want to learn more about general lawyering and have a few more hours to kill before going back to doing something productive, I would like to recommend the YouTube channel LegalEagle. He's a 10 out of 10 dude with charisma to spare. If you enjoyed this video, consider doing all the YouTube stuff and I'll see you some other time, or whatever.